A company's obligations to its workers and liability for their actions typically turn on their status as employees or independent contractors. It's not very hard to tell the difference in traditional workforce settings, but the gig economy has blurred this line. Saleem versus Corporate Transportation Group attempts to provide some clarity. Mazhar Saleem and several others drove for Corporate Transportation Group, or CTG, a black car service company in the New York tri-state area that mainly provided transportation to employees of large corporations. CTG established standards for driver conduct and vehicle cleanliness. An elected committee comprised of drivers enforced these rules. CTG also negotiated the fares with the clients and operated a dispatch center that received and distributed client requests to the drivers. All drivers supplied and maintained their own vehicles at their own expense, but operated under CTG franchises. Some purchased franchises directly from CTG. Others purchased or rented franchises from other drivers. CTG couldn't terminate a franchise agreement unless a driver breached, but the drivers could and did terminate at will after giving notice. The drivers made their own hours, chose what city zones to service, accepted and rejected client requests autonomously, and decided how to acquire CTG clients from a selection of 3 options. They also freely drove for other companies, private clients, and street hails while working for CTG. Saleem and other drivers sued CTG in federal court under the Fair Labor Standards Act, claiming that the company should have classified them as employees rather than independent contractors and owed them overtime pay, among other things, as a result. The district court granted CTG's motion for summary judgment, ruling that the drivers were independent contractors as a matter of law. The drivers appealed to the Second Circuit.